For today's hustle session, we are going to learn about how to find Department of Defense patents that can be licensed by the commercial industry, and once you have found the right patent and have prepared your license application, learn the Air Force Research Laboratory process in negotiating and obtaining a license. This is a key technology transfer activity that the government supports to take research developed for government purposes, such as national security, and repurposing for commercial use to promote economic growth for our nation. So now I'd like to introduce Sean Patton from TechLink. Sean, can you tell us a little bit about yourself and your organization up there on that microphone, please?
Hello, I'm Sean Patton, and I'm from TechLink. And I think to really understand what's going on in tech transfer, we have to realize that tech transfer is fairly new. Certainly, before the wall came down, the DoD labs did not interface with companies or with just the general public. Post the wall coming down, there was this time frame when in the DoD. What are we doing? What are we supposed to be doing now? And what are the threats? And out of that grew this idea that now we can be impactful to the economy, not just support the warfighter. And so in that vein, TechLink was started about the year 2000, and we were the first PIA, and we were run out of the Pentagon, and it was a test. It was just can something like this work? And it turned out that everything worked out pretty well, and the DoD was happy with what we were doing and the process. And that was kind of the start of tech transfer from all the research labs. So as TechLink is a national PIA. We are the owners of the T2 PIA network for the DoD. That is managed by the Air Force. It's an Air Force contract, but it's all other parts of the DoD that does research. So we're the manager of all of those, the tech transfer for that process. And starting out, there was in just a handful of labs. There was AFRL and a few Navy labs, and now there's got to be 40 or 50 different organizations in the U.S. that are using tech transfer legislation in some way. So there's been a lot of growth, and it just seems like there's more, especially with more PIAs providing help in their local area or nationally. So some of the main things that we do, kind of feet on the street for the organization, is we look at every piece of published IP, and we look at the claims, and we evaluate that, and then we put that information in some form on our website. And our website is divided up primarily by labs. So a certain lab, if you're looking for something from Rome Labs or AFRL, you can go and you can find a landing spot, and you can literally see every piece of published IP that is available from this lab. And then there's we do that for a lot of labs, all the Navy labs, Army labs, all the even Tinker Air Force Base is doing it. So that's the main service from the website type point. The the key part, though, really is we are a metric organization. So the DoD gives us, we have hard metrics. We have to meet metrics every year. And primarily those metrics are licenses. So our job is in that vein, is to help companies, help American companies acquire the intellectual property and the technology to further their company, or we do a lot with startups. And so this is a growth, an economic benefit for the country. And then there's other things that we do. We do award writing for FLC awards, and we also, one of the largest things, or the kind of one of the most important things that we do right now, is that we do an economic impact studies that are done. It's a double-blind study, and those studies are on our website, and you're shockingly successful in the DoD system in their economic impact for the economy of the United States. And those reports are there, and you can read them and see how important these efforts are that are going on in the labs. One of the latest things that we've done and this is for the lab infrastructure mostly, is we've started what we call T2U, and it's essentially a training for all tech transfer people across the DoD, and it's a fairly rigorous class. But then you go through this training program, and it's proving to be highly successful. So I guess with that, I can answer any questions.
Well, actually, I was going to help. I know you were doing this on purpose, right? Because we're going to, DoD or anybody in the Air Force loves our acronyms. So for all you people out there, Sean used some acronyms. DoD is Department of Defense. You heard what IP was, which is intellectual property. A PIA is a project intermediary agreement. Partnership. See, I don't even have that right.
Partnership, intermediary.
It has P in it. And then FLC is the Federal Lab Consortium, which is a consortium of all of us that work in this tech transfer type activity. Also, Sean, if you don't mind, I want to. Can I take a little bit of time to talk about your website and how I've used it personally and how we interact with you?
Sure. Yeah.
Okay. So if you go out to TechLink and just search TechLink on the web, you'll hit their website, and one of the first things you're going to see when you get there is you can type in a set of technologies, and you can actually string them together to make finer grain type searches for patents that you are specifically looking for across all the organizations that Sean talked about. And I've gone in there and I've done it, and there's a lot there. And then they represent, according to, you look at the website, they represent 46 different labs. They have captured 3,363 technologies. And you can search their areas by communication technologies, photonics, materials, software, medical, military, energy, electronics, sensors, and environmental. And a key relationship between TechLink and us here at Griffiths Institute, who is the Air Force Research Lab Information Directorate's PIA, is that we have our databases set up that we first search our inventory of local produced intellectual property patents, and if we can't find it, then we will help assist you by turning you over to TechLink, and so you could search nationally for that technology, because we all have the same common mission, which is supporting national security and the economic growth of our country. So it's a really good website. I highly recommend that you go out and check it out, and you'll find your time useful. So I wanted to give you some plugs there. You're just too shy, Sean. You need to up your game there a little bit. So now, with that, I am going to open up the floor to any questions that our group here may have. Is there any questions from the group?
One of the things that I think is important to say, and I might not have mentioned this, is we do a lot of support for the licensees. So it's a corporate, we're not just representing the labs, and certainly that's important, but more important is how we interface with companies. If there's a company that wants to either enhance something they're doing with intellectual property from the DoD, or startups, or that kind of thing, we help those organizations through the process of acquiring DoD IP.
So actually, before I turn it back over to our teams here, could you go a little more in terms of what you actually do, Sean, in helping them getting their license packages together before they go to the local organization that does that? In other words, I know you help with business plans, for example.
Well, yeah, so we call them commercialization plans because business plans are something different. And the structure of the DoD is if you're applying for a license, there's a checklist that the lawyers need to see. You have to address very specific things. And you don't want to address things that are not on the list because it could cause you a headache. It causes the DoD folks a headache. Oh, they said they're going to do this. We can't do this. And so what we do is we have a very good process of working with those companies, putting in exactly what the DoD lab needs to see, and all the right stuff is there, but nothing makes it onto that could cause a DoD order to go, oh my gosh, we can't do this. Our job is to make sure that when you submit, the lab, they might have questions, they might have, there's going to be a negotiation, all of that, and we can help set that whole thing up. But there's not going to be any heartburn. There's not going to be, we just can't do that. When you submit, it's going to, it's ready to go.
Yeah, so for our hustle teams, like you're getting a lot of work in terms of business model canvas. What happens is you basically take that same product that we're helping you with, but then you convert it to a commercialization plan and how you would have to give it here. So all the stuff that we're teaching you is applicable here. So when we talk about dual use, when you're doing that business plan, with the model canvas, the same information, or a lot of that same information, is being transferred into the commercialization plan to allow you to get to the licensing. So that's just another good example of, and we will help you make those transitions, but Sean's a very good person. He's done a lot of them. I don't know, how many licenses have you done in your career? Hundreds?
Oh, probably over 300.
Yeah. So he's got a lot of, he's a good person to know, and very helpful. And there's many other people like him representing other labs, those 46 labs that we were talking about. So I'm asking a lot of questions, team. Oh, here's one over here.
Thanks, Sean, for being here. Appreciate your insight and your knowledge. And so I was thinking about some more practical questions, sort of like a little bit of the day of the life of Sean, I think, in some sense, right? So love the website. It's pretty awesome. If you guys haven't been there, you get as much information as you can, including sometimes the real full patent, attachments. It very much gives you good abstracts where you can find things. So, but if I do find something, I think this is great. This, I think, is for me. I think I submit through the web. Is that routed to someone like yourself? Like, take me a little bit through sort of like who am I likely to talk to next after I find you through the sites, or find an IP through the site, and then maybe just give us a sense of like the fastest one you've ever seen, the longest one you've ever seen. There's obviously many steps of negotiating and back from TechLink to the local orders and all that, but tell us how it might practically look from a workflow from like the time I hit it online.
Yeah, that's a great question. So I would say, there's been license projects that have taken 2 years to close. I think the quickest we've done is probably at like 10 days. So I would, those are the outlying,
Extremes, yeah.
that's I would say that the most of the time, that you're in, it's probably a month to 6 weeks, if everything goes well. And so, it could be quicker than that a little bit, but, and again, it depends a lot on, I do a lot of work with the NSA, and their license takes 6 months, and that's just the way it is.
Yep.
And so, if you're looking at the NSA or something, that just understand that doesn't mean you're not going to get the license. It's just going to take a little while. And then, and the other thing is every organization has a culture and they have a tempo, and so at TechLink we kind of understand which labs, we can do this one quick, or this one's going to take a little bit, but we can get it done. And so as a licensee, we share that with you. Don't think you're going to walk away with this in a week, but there's a good chance you can get it in 6 weeks. And so
that's awesome. And it sounds like, in some sense, you're an agent, really. Like you're fielding these things, you're preparing, keeping out any of the red flags and the immediate showstoppers, and you're making probably introductions to those local orders, I guess. So help me understand. Is it the potential licensee and you're like one-on-one and you're my Sherpa, or do you make handoffs or outreach? Like, does it always get routed through a TechLink person and it's sort of like my agent that rides along with me? Or should I expect to have to meet or then talk or interface with a different office when it comes time to the negotiation? How far along the ride is TechLink with the licensee?
So the whole way. So we'll be there kind of the whole way through the process, and and help you through whatever the problem, if there's a problem, or just the time frame. And it really is that every lab, every Navy lab within that, the Navy labs are pretty homogeneous. And yet they still have little quirks. This lab wants this, and so we're just along, making sure that process is just keeps moving forward, and then helping if there's any kind of hiccups and in the process, we troubleshoot that and just get everything back on track.
Cool. And then the final sort of practical workflow questions are when does the licensee, or in this case a lot of these startup companies, when do they start having real expenses? Like obviously there's time and effort, and that's always an expense, but is there a fee to have your TechLink agency work usher me through? Is there a fee to apply? Should I expect to pay some sort of lump sum when the license begins? Where do costs normally incur, and maybe you can give us a sense of the range?
Right. So TechLink is fully funded by the DoD to do this. So there's no cost to any company to go through the process. The only process is when you negotiate with the lab, the owner of the IP, on the licensing terms. And that, and in general, the DoD, they're more in this for economic development, and a strong economy is a big weapon, for defense. If our economy is strong, if people are starting companies, that is that's a big tool. So they give us the money, and none of that gets passed through. The only thing that you have to do is that lab will put on, just like in the real world. Sure. You have to pay licensing fees, royalty rates. And those can be very flexible. Mm-hmm. And the only thing I can say about that is that in general, those costs are orders of magnitude lower than what you would get if you were licensing from another company.
A private sector license.
Yeah, private sector.
That's great. And I guess I lied. One last one. I saw some reference on the site about like is there like a fast track program or a quick turnaround version or something like that? Some of them are labeled that way. What's that
Well,
like? Or
so
is that
yeah,
Yeah.
boy, that should be off the website. So
Fair
there
enough.
was a we experimented with a like just a quick licensing model that
Yep.
so a lab would just say you can have this one for these $5,000 or whatever,
Right.
and we'll just write you a license. But at the end of the day, the company really does need a little bit more. They need to interface. Obviously, I mean, the first thing, if they need to talk to the SNEs,
Yeah.
they need to talk to the SNEs. They
Sure.
need to talk to an engineer at the lab. And that can't be done on a quick licensing type model.
Gotcha.
And so we kind of,
So it was an experimental model, but actually it turns out, while it may have been fast, it didn't really wrap the value around of like
Right, I think-
understanding where the IP came from.
Right,
and
I
what
think it's
good.
better. Yeah, it's
Yeah.
better for the company to have a little bit more hands off than just
Nice.
doing some kind of a fill in the blanks.
Great. That's awesome. I appreciate the perspective. Those were my questions. Thanks.
I'll hop in here. I have a question. You made mention that you obviously you go to all the different branches. When you look for your IP or your whatever you're licensing, do you have to know which branch came up with it, or is it a generic search? Do I have to know that the Army lab developed it or the Air Force lab developed it, or I can just go, I'm looking for this technology and it'll go wherever?
So if you can identify a tech or a patent, we'll find it.
Okay, so it's not branch specific.
Right. Yeah. And so we can find that piece of IP, and all of the IP for the whole DoD is on our website.
Yeah.
And so you can look at our website, and there's so much, in fact, that sometimes you kind of have to look around. But if you know the lab, or certainly if you have any kind of a patent number or a patent application, then it's easy.
I think to Greg's point, like, if you want to limit it, there's ways you can drill down through some search engine tooling. But if you're really just saying, like, I need a nuclear thingamajig, right? You could try and keyword search on that, and you might, to your point, Sean, you might find 50 of those things across, you have to start getting weaning down. But there's nothing here that's like, okay, now I got to run a search over Navy because I know I want something from the Navy, and now I got to run a search over Air Force. That's the beauty of TechLink search engine.
Yeah. So thank you, Sean. My first question is there an expiry date on this licensing? Do they have expiry date? And two, how many IP can one license in 1 year? And three, do you take a percentage on the licensing? If you have someone with it, do you take a percentage?
Yeah,
First was around expirations, right? Right. So when I'm signing a license, what's the typical expirations? And I guess in some sense, do they expire as far as when they're available, right? Like, let's take them one at a time. How about that? Does that work?
Sure.
So-
yeah. So the license. So the license is patent law. So the patent itself is in effect for 25 years. Yeah, 27 if they keep the maintenance payment. So that's all just USPTO stuff. You can find all of that and the life of the patent.
So I just want to clarify there. So for example, something may have been disclosed at this lab in 2005, right? Well, in some sense, it's a little aged, right? Its protection might expire in the next 5 years versus, say, a patent that was released in 2020, and it's only 3 years in. So that's a decision that the licensee considers. Like, how long and how valuable is this thing protected under the USPTO law? But chances are you can find the 2005 one and the 2021 through the TechLink searching.
So and actually, it's interesting if you start looking at intellectual property. Some companies have been successful in getting an older patent because when that older patent expires, they don't have to pay any more royalty rates. So they can acquire a technology and go to work on it, and then within a couple years, royalty rates are off, and they're off and running with no more payments.
Yeah, really good point. And I think, Victor, you were heading to your second point was around concurrent, like how many can I do in a year, or how many, am I limited to how many I can have at the same time? Are there any limits we should think about from like the volume of patents a company could have through a TechLink?
Well, you could do one a week. I mean, you can, as fast as you can write the commercialization plan, and as fast as the lab can go through the process of granting, and I don't know, RI takes about, what, a month, 6 weeks? So, you know.
Do you want to go on record? I don't know.
And then, you know, and within the labs too, and some labs are better than others, the T2 office has a relationship with some S&Es. And so if they get something for that S&E, they say, oh yeah, well, we got that one. We know the tech, we know everything about it, and you can just fly through.
The last question, do you take a percentage on the licensing?
No.
Right.
We're fully funded by the DoD, and we don't get any money from any deal.
Right. Right. So TechLink is the honest, neutral broker paid for by the federal government, right? Part of this mission to get a healthy economy is a good defense, right? Now, that doesn't mean that the licenses are free, because they'll come down to the individual lab that owns that intellectual property. And they may have royalties or maintenance fees or other things like that. But the neutral broker in the middle is not in to get paid or to be contingent on the percentage in the deal.
And if you know, I think I said earlier that we have hard metrics. Our job, we get measured not on money, but on how many deals we do. So as TechLink, we want you to succeed. We will do whatever we can to get that intellectual property into your hands, and so you can start making money. That's our win.
Victor, did that cover everything? Yeah, awesome. So I'll see then if there's any others.
Okay, any more questions from our hustle teams? This has been really, really good. And Sean, I thank you. You hit a lot of the good points, and this has been a really, really good discussion. And
if there's any questions, you can always call me. It doesn't matter if it's my technology or not. I can give you advice, and I can put you in touch with the TechLink person that is the owner of the IP, you know. So but boy, just give me a call and we'll figure it out.
yeah, so for the hustle teams, we got a question here. All right, let me say this real quick, and I'll let you go. We all work as a tight coupled team. We're constantly talking to each other. So if you get to any one of us, we will direct you where you need to go depending on what you need. So think of us as the network that helps with T2. And any one of us, we talk all the time, and that'll work. So we have another question for you, Sean. You're not getting off the stage yet.
Hey, so let's say like we go through the process, we get approved and everything, and like we use the technology and it's, you know, really useful for us. Are we allowed to like take that technology and manufacture it or improve upon it? Like how does that work when it comes to?
Oh yeah, baby, yeah,
We can?
that's
Okay.
the goal.
All
Yeah,
right.
so it's you can be a successful business person and start making money from that DoD IP. That's the win for everybody in the process.
Okay, and like, do we have to like? Is there any like kind of cash to that? If we're successful, do we have to like, you know, share stuff with like maybe the Department of Defense or like give help them out or stuff? Like, is there any like just cash that?
So
to be aware of?
there will be a royalty structure,
Mhm.
and you get to negotiate with the lab. I help you with that.
Okay.
And so, you know, and it's, you know, it's amazingly cheap compared to most of industry.
Thank you, Sean. Is it in the form of equity, the negotiations, or just monetary?
Cash.
Okay.
It's just, yeah.
So once you sort of have this deal, right? Part of the negotiation, Sean is right. Rate, royalty, when. Part of it is like field of use and or geography sometimes. Like, is it worldwide? Can I use this anywhere? Can I only use it in the vertical, say that's around these couple of tech sectors? That's part of that negotiation. And then remember, the government may want to keep part of it for a warfighter application, right? That's also part of that negotiation. But as far as and then depending on your terms, if you own that piece or you have the rights to that piece, you can do follow-on IP that's related to it, but because you own the rights, you can sort of broaden your IP portfolio. If you do work that's incrementally new, you can file extensions or second patents and additional, you can build a landscape around it. So it does give you the freedom to operate, and that freedoms defined about vertical and geography and all that are part of that cool negotiation they help you with.
So, and just to follow on with that, anything that, if you're asking for any exclusivity, that has to be publicized. So the beauty of a non-exclusive is that deal doesn't have to be public. And so you can essentially get a non-exclusive and go to work on it, and nobody can tell anybody else that you're working on something. So, if it's, a fast-moving field or that, everybody generally thinks, oh, exclusive is better. There's a lot of times exclusives are not better. They're cheaper, and nobody gets to know about them.
So let's say maybe for a company money might be a little bit tight. Are you able to negotiate a price? Maybe you pay a little more in royalties at first and then pay more later if you need more cash, or can you negotiate something with that?
Yeah, she's right there. Yeah,
Okay.
And so that's exactly what they do. It's their job to, they have to balance the impact on society, what you're doing, and then what they need, from the lab perspective. So.
Okay. And one more question. So are multiple people allowed to be have the same IP? Could multiple, say we're a drone company, say multiple drone companies want the same piece of technology. Are they all allowed to have a piece of that, or is it only exclusive to one company?
So if there's not an exclusive license, then more people can do the same thing.
Okay.
And in fact, there's a lot of that. You talk about drones, that IP is really moving right now, and this, it's hot right now.
So we licensed the version 1 of a technology from the Air Force. We built V2 based on that technology. Is the Air Force going to own that V2 as well, or?
Well, so it's by the intellectual property. It's dependent on the patent.
Okay.
So if there's more, if the lab keeps inventing and adds some new cool things, you would have to come and get a license for that additional.
Okay.
But if you create your own stuff based on that, that's yours.
Okay. Thank you.
Any more questions from the group? Well, I think so. I think they set you up pretty good, Rachel. And one of the things I had a list of questions for you, but actually, Rachel, before we get into deep into the licensing process, could you really tell me about yourself and what your specific job is in the lab? Because I think they need the context, because when I said the intro, we said licensing technology is only one part of the T2.
Right.
And in reality, we, the Griffiths Institute, work for you.
Yes,
So-
absolutely. Yeah, no, you guys set this up really well. So I took lots of notes to cover some things. But let me just give you kind of high level. So myself, I'm Rachel Mann, and Steve Clenzo was in here earlier. We're kind of multitasking today, so he had to step out. But we are part of the ORTA, which is Office of Research Technology Applications. And so that is under our T2 office, Tech Transfer Office. And so together we handle all these license agreements. We also handle other T2 agreements, CRADAs, my gosh, collaborative research agreements. We have EPAs, educational partnership agreements, and then we do different transfer agreements, material, commercial test agreements, all these fun things. And so licensing specifically is a really good opportunity for our tech transfer community within all the labs across AFRL to make sure that we are helping, the outside sector, the private sectors, these small businesses, any of you guys come in as well as us work outside of the labs. And so working with TechLink, working with a PIA such as the Griffith Institute, like Dan was saying earlier, we're all talking pretty much daily on all of these things. And so licensing, for example, for just this year, and we're only in June, which is really great, and that's a huge part of TechLink and Sean working with us. And so, all right, let's see, did I cover that? So I'm a civilian at the Air Force Research Lab with Steve. And so kind of our process is through Sean or through whatever opportunities you have, such as Hustle, you'll get a hold of us. And so typically that commercialization plan and an application to license comes to us, and that's a lot of where our conversations start. And so you will have a signed commercialization plan as well as an applications for license in an email to us that says, hey, we're ready to license. Sean usually gives us a heads up. I've been working with these guys. They're off and running. Let's figure out how to move forward here. In that comm plan, you're going to talk about all of those things you mentioned, right? Do you want exclusive rights? If you don't want exclusive rights, what field of use, what area specifically are you trying to garner? And therefore, are there other opportunities for other businesses to get this technology as well? All of these things in that comm plan, we are going to take in consideration with our negotiations with you. And so if it is new hot technology that a lot of companies would like, or we've gotten a lot of requests for that IP, we're going to take that in consideration. Maybe the prices are a little bit higher because there's a lot more need for it. Maybe it's something that's only got 3 years left on it. We're not going to ask for a lot. We are going to protect the IP through the end of it. And so therefore maybe it's $1,000 at the start and a small percentage year 1 and 2, and then it's over in year 3 anyway. So these are all very fluid. They're all very different from each other. None are really the same per se. Sean's really, really good at talking to you guys, getting a feel for what your plans would be, what your intentions may be, and working out pretty reasonable numbers that we typically will speak with him. We'll talk to you guys and say, we're pretty on target, maybe some minor changes here and there. I haven't experienced a license agreement that came from Sean that we said, nope, this is all wrong and we got to start from square one. It's not typically like that. All right, so you fill out the application, you fill out the comm plan, you get to us, we have a quick meeting, make sure we're on the same page. We then start our process internally to the labs. And so that process does include a publication to the Federal Register if it's an exclusive license. So when we talk about how long these things take, bare minimum that has to be posted for 15 days. It gives the rest of the world an opportunity to give any objections, any questions, concerns. Not typical, but it can happen. And so for sure, that's 15 days. I want to say it's a good month outside of that to get those things posted. We consult with our own attorneys and internal to the labs. So on a really good day, a month is probably a really good average turnaround. We've had some process improvements in the last couple months to start seeing that number come across, which is great. On a bad day, yes, it can take a lot longer. If you get objections, if we can't really get to standard ground on negotiating, which isn't common, certainly things can take longer. So we get something posted to the register. We work on a PLA, our patent license agreement, whether it's exclusive or non-exclusive. A lot of that has standard terms and conditions. A lot of those things, there's not much wiggle room. Our lawyers are the lawyers. They're great at what they do for a reason. And so those have kind of already been negotiated higher Air Force-wise, pushed down to us. This is, the realm you can stay within. We work on that language. I fill in a bunch of the template. We'll send it to the lawyers for their sanity check, and then we will get it out to you guys. You're welcome to read through that. If you want to consult with a lawyer, any recommendations that you may see, we can certainly work on that. Typically, like I said, it's pretty standard. We've already negotiated the royalty terms, and there's a whole article for the royalties. And once we all agree, that goes out for signature. So you would sign it first. It would then come back into the labs. It's going to do a little bit of a rounds for signature. And ultimately, the agreement is executed when our colonel, the director of Rome Labs, signs that. So, maybe a month, maybe for signature, another 2 weeks if it's summertime and he's traveling a lot. And then we're off to the races. And so term, that can be essentially the standard for us is usually the life of the patent. Now, at any time you can terminate the license, at any time you can modify the license. Maybe a year in, things with the company, you changed routes, maybe you have a whole new idea, this is kind of old news for you, let's just terminate it. We don't want to incur costs on your company that aren't needed. Happy to terminate. Happy to modify if you say, you know what, I got non-exclusive, we really got to talk about this. There's more fields of use that we didn't realize, or there's other things that we're exploring. Maybe you're not quite where your company thought you would be in turning out revenue, and we put a percentage of revenue on there. Well, let's modify that agreement and make it realistic so that we're not bankrupting anybody. We're not in the business of doing that. So maybe you had a $1,000 minimum royalty payment due. Maybe not going to meet that. Let's modify that before the terms are due. We can absolutely modify what you will owe in the future. We cannot remove a debt, and that's very, very important in our license agreements. Whatever was set is what we need to follow unless we modify on time. We cannot modify later and absolve you of any payments. And so very important, very, very happy to work with anybody. And so if you work with Sean and you say in 3 years we think we're going to make some money, 3 years comes and you're not quite there, let's modify that. Let's make sure that you guys are on target for what you need to do. So those are very, very important things in my opinion to hit on. Let's see, executed. So we talk about agreement years. We start at the time of execution for the kernel signature, and then you're going to have built out agreement years in that. Our newest, latest, and greatest process improvement is a cover letter. We're going to send you the signed agreement with a cover letter that is going to be very clear in all of your milestones and what the agreement years are going to be. And that is going to coincide with the length of either the patent or what we agreed upon in the terms of the license for term. If you want it for 5 years, if you want it for the life of the patent, things like that. Let's see, the last 4 are pretty much all the life of the patent. 1, the patent does expire in 2.5 years. And so that gentleman is going to do what he can with it in 2.5 years, and then it's going to be open IP. But hopefully he's ahead of the game for whoever else would want to use that IP. We do keep TechLink in the loop, and so Sean will kind of pass you over to us, but I like to CC Sean on every email, any update that we give you guys. Such a great resource and somebody to have in your back pocket, and so TechLink is absolutely involved through the whole process. That is very good to know. IP process, I think that's all I had off the get-go.
Yeah, well, I was going to add to it. So, so one of the messages and a key takeaway that Rachel was telling you, and what Sean did too, is we want you to succeed.
Yes.
I mean, and they're open to do whatever it takes to succeed, and that's the main thing. So they're there to help. Seriously, we're all here to help you all succeed. The other thing is, do you want to talk a little bit about partial licenses?
Exclusivity?
Partial exclusive?
Yeah. So you can ask for partial exclusivity. Essentially, we're going to still call that exclusive. We only have 2 boxes we can check, non-exclusive or exclusive. And so if you want partial exclusivity, absolutely acceptable. You're going to note that in your requests in your application. But we are going to make sure it's very clear in our fields of use is the wording we're going to use there. And so whether that's, you want this in the field of use or a partial exclusivity for government application. Maybe you want it for educational applications. So there's a lot of options there. And that's something that I highly recommend that you make very clear in your communications with Sean. And so that way all of that is very upfront. When we get your initial email, I'm essentially going to review your 2 documents to make sure that they're complete, and those things need to be very clear. The biggest reason I ever kick anything back is that a box is checked, but what's written is not quite what the box is asking for.
How many months does it take you to grant an exclusionary licensee?
I missed that second word.
Are you talking about an exclusive license?
Okay, yeah. So I honestly, for exclusive, it's that 15-day publication. And so I will admit we send that up to the Federal Register as a request to be published. It has to sit once it's published for 15 days. So I would say in a good process expedited, about a month and a half for exclusive. Non-exclusive can be a lot faster because we don't have to do that 15-day submission.
What if multiple companies are trying to do exclusive at the same time?
So that's something, I mean, have I experienced it? No. Sean probably has more experience there. But that is where we have to take in consideration of, what's being requested. And so are they exclusive in that partial exclusivity, or are they fully exclusive? And then what are the terms that that we are going to negotiate? It's going to make the numbers for our rates a little bit higher for sure. But ultimately, who gets selected? That's going to be a lot of internal lab conversation. We're going to consult TechLink, and we're also going to consult our S&Es. What's the future of this technology? I would assume it's a more hot topic research area, and so where are we going with it? What is the military use for it? And then we'll ultimately make a informed decision based on that information.
Any more other questions for Rachel before? I'm not going to let you get off the stage just yet.
Okay.
But Joe, you want to get ready to come up? One of the things is just to help talk about the teaming. So we actually share information. So every time a license gets approved, whether it's partial, exclusive, or non-exclusive,
Yep.
we have a database that we share. So if you made an inquiry into us about, can I get this patent, not only will we look and see when it expires, we'll actually look at their license database that they use, and we'll be able to tell you if it's even available.
Yep.
Even before you go through all of this stuff. And so that's just one way we're communicating between each other. So like, don't try to do it. Don't even go through the process because you can't get it anyways. And so that's, again,
Yeah, we're not trying to waste your time.
Yeah.
Yeah. Yeah.
So I guess, Rachel, you're good to sit down, and we're going to
Cool.
bring Joe Mancini up.
Thank you.
Where is Joe? Okay, yeah, Joe, you got to go to the microphone real quick. Joe, you want to tell, before you get started a little bit here, what I'd like you to do is, I'll help you a little bit. Joe retired from the Air Force Research Lab. He was the prior patent lawyer over at the thing, and so I've asked Joe to talk about how, in his job there as that patent lawyer, how he interacts with the ORDA team to get you to the licensing, and then you can just segue back into then what do you do here now at Griffiths that is also a service that we offer as part of the T2 mission we do for the lab. So, floor is yours, Joe.
Okay, well, my name's Joe Mancini. I'm an employee of the Griffiths Institute. I'm the general counsel here. And I'm actually a stand-in for the Air Force Research Lab's patent attorney, Randy Jones. He's traveling overseas, I believe. So I'm not speaking for him, I'm speaking instead of him, okay, when I tell you anything here today. I held that job at the Air Force Research Lab for about 30 years as Randy's predecessor. Primarily my job was patent prosecution and patent preparation. I got involved in licensing. A lot of the issues that are involved in licensing between Sean and Seth, they've already covered the business aspects of them, okay? How we come to terms with the potential licensee, they cover it very well, and they did cover it very well here today. I think Rachel mentioned that the attorney makes a sanity check on that license when it finally reaches his desk, and we do. Dan, is this kind of free form, or did you have a form? Okay.
The floor is yours.
What I do in that job, or what Randy would do in that job. Let's see. We won't second guess the business judgments that have been made, but we'll make sure they're sound. We'll make sure no mistakes are made in judgment. All right, but we don't second guess the judgment per se. The royalty rates have been arrived at due to exclusivity or not exclusivity. The remaining term on a patent before it expires, the value of the technology, which, by the way, TechLink is very good at, because of the breadth of their experience, they're very good at evaluating what technology is worth. Hardware versus software, you get the idea. So we'll run a sanity check on the license when it crosses our desk. How about this? Is the patent, or, by the way, the Air Force can license pending applications as well. All right? If the potential licensee really wants to get a jump or a head start, they can license a pending application. Well, there's risk involved with that. Not all applications mature into issued patents. But, if it does, they've got an automatic license to the patent, should it issue. So is the patent, or let's say the patent, is it actually available for licensing? Well, I'll tell you what actually happened once, and we remedied it very quickly. We were about to license a patent, and in one of my sanity checks, I realized the last maintenance fee had not been paid. So we would have issued this license, and lo and behold, maybe in a week or two, we would have found out the patent went abandoned. And that would have been very embarrassing for us. It would have jeopardized the license, but we caught it and fixed it. So that's one thing we do, before the license actually goes out. It's available for patenting. Has a patent already been encumbered? Did we already license it? Partially exclusive, exclusively, non-exclusively? That affects the value of the license in a whole deal, basically. And that needs to be communicated with the licensee. There's all kinds of licensees. There's, I say the newbies. They don't know to ask these questions necessarily. So we have to be extra sure we get it right for them. Then there's sophisticated licensees like big tech companies. They will have done all their due diligence already. All these things I'm saying that were potential mistakes that could be made, they would have already analyzed all that about the patent. They would have looked up the maintenance fee status. They would have looked up the assignments on that patent, because they're all recorded in the patent office. So there's all kinds of licensees, and we take that into consideration. Let's see. Okay, maintenance fees. I think the default patent license, and Rachel, you can correct me, at least the last ones I dealt with, the Air Force pays the maintenance fees. It doesn't have to be that way. You can negotiate it either way.
So the standard as of lately is that the Air Force pays the first maintenance fee at 4 years, and then at 7, it's 4, 8, and 12. So 3.5, 7.5, and 11.5, you can start your payments. The Air Force will pay the first one, and traditionally in the last couple license agreements, we are having the licensee pay the 7.5 and 11.5 years. Certainly something you can bring to us and say, we're not interested in doing that, and maybe we negotiate, that money elsewhere.
Yeah. Thanks, Rachel. We had a really good run at the lab over the last 20 years, and we had enough royalties coming in from our patent license that we were willingly paying the first, second, and third maintenance fees on behalf of the licensees. Apparently that's changed now. And I think it's changed in a way it should, to be honest with you. All right. I think this was mentioned, forget by whom, but when we issue a license, that license covers any continuations and divisionals. So all these, let's say we license a parent application, right? The first invention of that type. As you know, there may be successive patents or applications filed on that same technology, that original invention. Our licenses, stated in their terms, cover divisionals and continuations. Not continuations in part, because that's a different invention. So the licensee potentially gets more than just that original patent for their license. All right? Dan, if I'm going down the path you want me to, good. If I'm not, just redirect me.
You're doing the exceptional job I knew you would do.
All right, I mentioned, is a patent, yes, sir.
When you say continuing on, in other words, talk in terms of software. If I buy or I license version 1.0 and 2.0 comes out, I automatically get a license upgrade?
Well, you mentioned software. So the first thought that comes to my mind when you say software is copyright, not patent. However, in the past we were able to, with fairly good success, license computer-implemented software methods. Okay? It's gotten a lot harder today. There's been some Supreme Court cases on that issue because software is analogous to a process of the human mind. It's computational.
Okay.
They've really scaled back how and when software can be patented. Generally speaking, it has to be combined with an apparatus of some sort. Software alone is really not very patentable anymore. But had that software been an invention in which an application was applied for, and if version 2 was patentably distinct from version 1, you could get a continuation or a divisional application on that software. I hope I explained it okay. Maybe Sean will help me
So
here.
the upgrade would be included in the license at that point?
If it fit the definition of a continuation or divisional, meaning it shared commonality with the parent
Right.
application.
Understood.
Okay. Yeah, Sean.
We are doing 801s, right?
We're doing what?
801s.
801?
Yeah, we're doing 801 Software Licensing Authority.
Yes. Yes. I've not seen any cross my desk here while I was at the Griffiths Institute, but my last couple of years at the lab, we did one, maybe two. There's a separate authority, I don't know if it's Air Force or DoD level, for licensing the vast repository of DoD software. So forget everything we talked about, patents and licensing. There's a separate license authority, basically analogous to copyright law for software,
So
where you could license DoD software. The actual code.
The
yeah.
actual code.
Yes.
Is,
And then the beauty there is if it's from a lab, if you enter into a CRADA, I don't know if those have been talked about yet, Cooperative Research and Development Agreements, you could actually access the know-how from the authors of that software. I mean, if somebody dumps a pile of code on your desk, great, right? But to have the actual access to the people who wrote the code, huge benefit. So that's a benefit of licensing with the DoD laboratories and federal laboratories as a whole. Okay.
So luckily that's all ORDA office, and so that's us as well.
Yes.
We can license like maybe 50 lines of code. You know, I don't know. Is that
Pardon me?
possible?
Oh, what about 50 lines of code?
License it?
Copyrighted?
Yeah.
The very first line of code is copyrighted. Yeah, that's, I say recent. Copyright law and patent law well, copyright law doesn't evolve very quickly. Patent law more recently has. But most recent form of copyright law, any work of authorship in which software is included, at the moment it's created, it's copyrighted to that author. Now, if you're a freelance software person and you work for a company, you're probably creating a work for hire, and that software you created is copyrighted to the person who hired you, not to you. You automatically assign that copyright under a work for hire. So keep that in mind. If you ever have a contract and it says whatever you create is considered a work for hire, that means your copyright is assigned to the person paying you. Yeah, work for hire. Important words. Right. To be able to license something, it means you have to have the right to license it. You have to have an ownership or some ownership interest of some sort. In the laboratories, every inventor, when they invent and we're pursuing patenting, they have to make an assignment. Even though they already work for the Air Force, they have to make a written assignment of their ownership to the Air Force. So what we want to make sure doesn't happen, and it does happen with regularity, is we go to license a patent and we didn't have all the assignments from all the inventors. Now, the attorney on the other end, the licensee side, he's looking for that or she's looking for that. They not just want to see the patent, they want to see that the Air Force acquired the assignment for each and every inventor. All right, and sometimes these inventors don't all work for the same employer, but they've collaborated in creating this invention. Now we've got to go out, not only get these assignments, we have to negotiate getting these assignments. So it gets sticky real fast. It's one of the aspects of the job I like the least, because you have to play catch up, you know. So let's see, where are we? We get the assignments from all the inventors. The basis for royalties, is it clearly defined? Okay, when you're involved in a license activity with the Air Force, the royalties are usually based on gross sales, a percentage of gross sales. All right. So if you license with a sophisticated non-government inventor, they might use different words to define what the royalties are based on. So you or your attorney will read that language very carefully. If it's something other than gross sales, we all know what that is, right? Every widget you sell for $10 a widget is a royalty-bearing sale. So 1% of all the widgets sold is $1, right? No, 10 cents. Yeah, that's why I'm an attorney. I wasn't an engineer very long. Okay, so yeah, what's the basis for the royalty generation? All right, again, in the government, the default is gross sales. But dealing with other licenses from other entities, it could be different. It could be based on profit, and you know, accountants can define profit lots of different ways. All right, so watch for that. We talked about exclusive, non-exclusive, partially exclusive. If it's a partially exclusive license, is a territory in which it's licensed well defined. All right. That could be geographic or it could be the technology itself. Okay. Okay. Federal Register, yes, 15-day waiting period before we can actually execute an exclusive license. Anyone know the reason for that? Not only the federal government, but almost all public agencies, whether they're federal, state, county, local, municipal, they believe in giving everyone a fair opportunity. And if we didn't advertise the fact that we were going sole source on a license, which an exclusive license is, we're basically eliminating competition for that license opportunity. So we make an announcement. If anybody has an objection, that's never happened in my experience in 30 years. I'm sure it's happened somewhere in the DOD. Have you encountered it, Sean? Or anybody objected during it? Yeah? I'm curious how they're resolved when that happens, because I've not encountered one.
Yeah, they were, it was a situation where somebody just didn't want the license or the technology out, and so the lab was able to issue it.
Okay.
It wasn't, it was just they said, we don't think the government should be doing this.
Okay, gotcha.
So it's kind of a, one of those people on kind of a fringe, I think. And so, but yeah, we have dealt with that.
Okay. I mean, as a hypothetical situation, if that occurred, I suppose they could issue 2 non-exclusive licenses or 2 partially exclusive licenses to satisfy both parties who want a license. Okay. Okay. So that's really all I'm going to say on patenting. What I do here at the Griffith Institute is everything related to tech transfer comes across my desk. We have individuals here who are primarily responsible, and they do the negotiating with the other party in T2 agreements. And we do all that. I call it pre-negotiation because we like to give the Air Force, who's going to put their signature on it, a copy that's ready to go, document that's ready to execute. And based on my experience and some of the other individuals here who work T2, who did work in the government, we know how far the rules can bend. We know what we can send over and not have the Air Force send it back and say, do it again. Okay, these terms are not acceptable. So we've got a pretty good knowledge base in that respect. So that's part of what I do. What I've done in the past here, I actually worked with the AFRL patent attorney when they had a significant backlog. And, when I left, it took a while before they got another patent attorney in, and patent matters tend to pile up, whether they're new disclosures or whether they're office action rejections from the patent office, all needed to be worked. So we worked collaboratively on that, and we got them dug out of their backlog. So I did do patent prosecution, which I thought I was done with once and for all once I left the lab. I come over here only to find I had to do it again for a while. But that was fine. I enjoyed it. I enjoyed working with the Air Force patent attorney. So yeah, anything related to T2, whether it's cooperative research and development agreements, educational partnership agreements, commercial test agreements, which is a lease, temporary lease of Air Force facilities, unique test ranges, things of that, anechoic chambers, things like that. I'll review those. Okay, from time to time, what comes across my desk are copyright issues. Either they originate here at the GI or they come over from the Air Force Research Lab. Trademark issues. I did a trademark practice while I was at the lab. Our Information Institute is something it's a registered trademark now. We did over at the lab when I was there. What else? We talked about patent licenses in the traditional patent license sense. We use a tried and true form over at the Air Force. But we're finding, particularly with universities, they want to do when we have mixed inventorship. And that means one inventor is from the Air Force, one inventor or more are not from the Air Force. They're from a university or from a company that works with the university. You name it, there's all combinations. They want to insist on what's called joint ownership agreements. That means both parties jointly own all the rights to the patent. The party, generally speaking, who pays all the patent prosecution costs, that is, they go out and hire the patent attorney, they pay the maintenance fees, they'll have licensing rights. And the party that doesn't do that will retain use rights. meaning they can still work with it, they just can't commercialize it. The party that licensed it and paid the bills, they get to commercialize it. So joint ownership agreements, we're seeing more and more of those now. I don't know if you knew that, Sean. Yep. And they can be challenging to work through, because it's not just one set of terms. You're trying to satisfy terms for both parties at the same time. And they can be very challenging. We've been working on one for over a year now with a local university. So I think that's all I had. Dan, anything specific you want me to address?
Well, no, but I'm going to say thank you. But one of the last messages, and I think you might have been picking it up a little bit, but I wanted to make it perfectly clear. Our job, Sean's, Joe's, mine, are to help people like yourselves be prepared to interact with the government. But when it comes to looking at and negotiating an actual CRADA or the licenses, we are hands off. We just prepare everything, and then it goes to the Air Force, and then we don't get involved, and we shouldn't be getting involved, and then when the license comes out, it comes out. But I wanted you to know we're no part of any negotiation whatsoever. We're just helping you get prepared and making sure that when the Air Force or anybody else gets it, it's close enough that it speeds up the process. And so that's how we're trying to be responsive T2 people. So I think that's a real key distinction, is we prepare, but then it's not our responsibility, nor should it be. I will ask my panel members, you got any last parting thoughts? And if you don't, I say thank you very much. And let's all keep hustling.